What's up, everybody? Welcome into another episode of The Lawyer You Know. And we are going back to court with Lori Vallow as attorney and client as a great example of why you should not represent yourself, even if you may be intelligent, even if you are a lawyer like myself, because you are just too close to the situation. You will end up making arguments and sounding a certain way that is not going to be very becoming in front of a jury. And we're going to get to hear some of that from Lori Vallow today, as she basically goes off in court and gives us an indication or a little insight into what this may look like throughout the entire trial. I want to know what you guys think, though, as you are the potential jurors in this process, and you can tell me whether or not maybe I'm overstating her actions and her demeanor in court today. So they are still dealing with a number of pretrial issues. Vallow's objecting to certain cops being qualified as experts, and the judge said, why? And she said, for 5 years, he's been a normal witness. Now he's an expert. Judge said, so you're not talking about his expertise? She said, no. Well, technically the timing to, disclose him as an expert was followed by the state. They didn't break those rules. She talked about how some witnesses aren't fact witnesses to any crime, so they shouldn't be available to testify. The state says they can testify to motive or have some other information, or Vallow has spoken to them, and that's what they're going to testify about in court. The judge seems like he's okay with that. Then we hear about Lori Vallow's attempts to call Nate Eaton as a witness, and it's kind of an interesting discussion that we're going to listen to as to whether or not it's appropriate, whether or not she's doing it for nefarious reasons, and how eventually the judge comes to his decision. So that's where we're going to jump in here for the hearing from yesterday.
Next I have, is there a Mr. Eaton here appearing?
Your Honor, Matthew Kelly, I represent Mr. Eaton.
Okay, you filed a motion over the weekend. Mr. Eaton or someone that he works with filed a motion. Mr. Eaton was, let's address that now while we have people here. Mr. Eaton was listed as a witness by the defendant. Mr. Eaton apparently is a reporter in Idaho, and based on the filings, believes he doesn't have any relevant information and shouldn't be listed as a witness. So let me ask the defendant, what relevant information would Mr. Eaton have? Why is he listed as a witness?
Well, I just got this last night, so I haven't had time to read all the things that he's claiming he doesn't. But there's several things off the top of my head that is relevant. Right now, one of the things is it's different now, right? Because he's had this off the record conversation with the prosecutor, and he's kind of made himself a witness. He's kind of made her a witness.
How so?
In the sense that if this is not prosecutorial misconduct, then one of them is going to have to testify and talk about how it's not.
Let's back up.
So this is an example of her not understanding exactly how the process works. She does make some arguments that are cogent and that you can track, even with Nate Eaton potentially having some impeachment material. We'll talk about how that could have been potentially something she could argue. She didn't do it right, though. She's not following the processes and procedures right. Nothing against her for that. That's why it's very difficult for lay people to be their own lawyers and to be lawyers anyways. This process is created by lawyers. The rules are made by lawyers. The rules are argued by lawyers. The rules are interpreted by lawyers. So it's very hard if you're not a lawyer to come in and just hit the ground running. But we are going to listen to some of this exchange. It's just very obvious she does not understand how it works.
How is he a witness to this trial? How does he have relevant information? Relevant information means a witness has testimony that makes some fact in the case more or less likely. So how does he have relevant information for what this case is about?
Okay, so initially when I put him on my witness list, my intent is because I do not know what the state is going to put on in their case in chief. And so I was calling him as a witness for the purpose of impeachment, laying foundation for interviews, rebuttal to whatever that the state might put forth, because he has interviewed almost every single witness on their witness list. And if they were to say something contrary to what they said to him on a public thing, then I would use him to lay a foundation for interviews and for impeachment. So that was my initial, in calling him. I found it funny when I read the beginning of this. He says that it seems to be clear attempt by Mrs. Daybell to use the rules of criminal procedure as a pretext simply to keep me out of the courtroom and interfere with my ability to report. So I had to laugh at that because it hadn't even occurred to me that he wouldn't be able to be in the courtroom if he was a witness according to 615. So
she's like, ha, You think I know the rules? Good one. She's like, nice try, Nate Eaton. You think I know the rules of criminal procedure? But here's what I think. I think she probably doesn't like Nate Eaton, if I had to guess, and wants to show him that it was a mistake for him to do these interviews and haha, now I got you. Now you're going to have to testify. I don't think he'd have anything good to say about her to testify, but potentially speaking, if we want to go with her train of thought, it's similar in the Gretchen Voss or other people in the Karen Reed case, which John said, it's nice to have a little break from Karen Reed. Yeah, these trials going on at the same time, going to be interesting. We'll see how it goes. There's also some Koberger stuff I still want to get to. Just tons of documents coming out that some of you guys are sending me. If you have questions on Koberger documents, send me the document you have the question on, because there's just so much. I am going to try to cover a piece of that this week as well, while we're just in jury selection for Karen Reed's case. But if she would have subpoenaed and gotten the off the record notes or conversations with Nate Eaton and anybody involved, I know he has interviewed some witnesses, some law enforcement officers, I think, have gone on and spoken to Nate Eaton. He says, or she says, there's this conversation between the prosecutor and Nate Eaton, which can be pretty simple. We're going to get to that eventually. But if she would have properly discovered and subpoenaed all of that information, and there was something in his personal notes that she could come out and say, well, the cop didn't say this to you, did he? He didn't say this, but now he's saying this on the stand, then potentially Nate Eaton could be an impeachment witness. But a couple of things there. Number one, there are arguments he still shouldn't be sequestered. Number two, the judge later, they argue about whether or not you actually need Nate Eaton to be a witness to get those impeachment statements, because if you have the actual video or the actual interview itself, you can just use that. You don't have to use Nate Eaton, but it would basically be for off the record conversations, but she didn't handle it appropriately. She didn't discover it. She didn't subpoena it. She doesn't have it. You have to actually say, hey, I have this off the record stuff that I'm going to use as impeachment. If you want to even try to get there, she didn't subpoena him properly. We're going to hear all the things she didn't do properly, which again, this is going to start to build and add to her frustration that she doesn't know the rules, which she admits here. She doesn't know how to do these things, and it's not going well before the trial even starts, which is, again, if we're looking forward to the trial, a good indication about how this trial is going to go for her. That's my opinion, how I see it going.
So that wasn't my intention. It was never my intention to do that. It was just to have him on hand if we needed to do that.
All right. Mr. Kelly, right?
Yes, Your Honor.
Mr. Kelly, in theory, it sounds like if a witness said something different than they reported to Mr. Eaton at some point, I guess in theory, she's right that Mr. Kelly could be called as a witness to impeach someone, but that's only allowed after the person's confronted with the actual statement that was made, and if they then deny that statement that was made. Do you have copies of his interviews and transcripts of interviews that you might want to impeach someone with?
I've been watching most of the interviews and I take my own notes, so yes.
Go ahead.
Your Honor, two things. One, excluding Mr. Eaton under Rule 615 would be a violation of his rights under the First Amendment to attend and report on this very public trial. But more importantly, Your Honor, if Mr. Eaton were to be called as a witness, the party calling him would have to comply with ARS 12-2214, which has very stringent requirements for subpoenaing and compelling the testimony of a journalist about information that journalist has obtained in the course of news gathering. As we state in our motion, we don't believe that there is any way that Ms. Daybell can meet those requirements, but I would suggest that if she wants to call him as a witness, she would absolutely have to follow the requirements of the subpoena law, and we would then have an opportunity to challenge that. But we don't believe that there should be any reason for Mr. Eaton to be excluded from the courtroom.
All right. I'm just thinking through this problem. If a witness got on the witness stand and said something different in testimony than you saw on an interview with Mr. Eaton, you would then play that interview. You wouldn't even need Mr. Eaton to do the impeachment, because you could impeach them with the interview by playing it for them in court or something like that. So now that I'm kind of thinking it through a little more, I'm not sure.
And I wouldn't need him to lay that foundation for the interview?
I'm really trying not to give you any legal advice because you are acting as your own attorney, but
Now, there are ways things could come up, right? You don't know what's going to happen in trial. To have him on the list in case you need him to authenticate something or say, yes, this is who I spoke to, or like I said, with the notes, then potentially. So I think the judge overall is right. And you can ask, Officer Smith, you did an interview with Nate Eaton, right? Is this you on this video? Is that Nate Eaton? Okay. And then play the video to impeach him. Basically, you can lay the foundation with the cop or whoever the witness is. I think she said he interviewed a cop. I don't know everybody he's interviewed. I know he has interviewed some people with this that are connected to this case, even jurors. But I think the judge overall is right, but I don't think it was the most asinine thing you could possibly do. Barely Hop said, Peter, you are pointing out so many errors. Why didn't her support attorney point this out to her? So I will tell you, and this is where the line gets crossed when you represent yourself. Tons of times I've had clients saying, I want to call this person. I want to call that person. I want to call all these people to get them in there and say X, Y, and Z. And I'm like, we can't have them testify to that. Sometimes they'll still argue with me. Sometimes we'll go back and forth. I'll send them a case and say, it very clearly says we can't call this person to say, that the person driving the other car was a scumbag and a jerk and a horrible driver, right? Just because, somebody posted on Twitter, yeah, get that guy, he's a bad driver, whatever, okay? My point is there are people that clients want to call all the time that you can't call for some evidentiary reason or, some procedural reason. There's not enough time before trial. They bring up an expert that they want the day before trial. We're like, there are rules. We talked about this. We didn't disclose them. We could try, but we're probably not going to get in. But when you are the lawyer, all of this to say, I don't know what her standby counsel is telling her, but it doesn't mean she has to listen to them, especially when she is the lawyer and she's the one making the witness list and it's on her. So we don't know what they're telling her. Maybe she isn't heeding their advice or maybe they're just not telling her. I don't know. But I will tell you, it wouldn't be the first time when a client wants to do things that lawyers would say, we can't do it or we shouldn't do it, and they still push forward.
If the witness admits that's them on the interview and that's their statement, that is foundation. So
He's interviewed law.
Yeah, but what if they don't admit that it's them, right? And she doesn't know to make that argument. But what if they say, no, that's not me? Then she could potentially call Nate Eaton, right? So I could understand kind of where she's going. I don't think he should ever be sequestered. I don't think this is a real thing where he would be a real witness. But if he's entertaining this argument, there is potentially a chance it could become relevant. And I think you allow her to potentially call him, but not sequester him, and he could be a rebuttal type of witness, even though it's the defense. But overall, I just don't think it's a real thing. I don't think Nate Eaton would ever have to be a witness. But if we're assuming arguendo for this conversation, I could understand that potentially there is a way that she may have to call the cameraman, right? What if Nate Eaton says it's not them? Then you call the cameraman who was there, and that's just not usually how it works. And that's where the judge is trying to go.
Law enforcement, almost all the law enforcement that's going to be, up here on the stand. So it's not just witnesses, it's law enforcement.
Well, when I say witness, I mean generally any witness, regardless of their occupation. So I don't foresee, I see it in only the narrowest of situations where he could even be called to as an extrinsic person to testify about the impeachment.
Generally, I agree with that. I agree with the judge there.
You'd have to jump through a number of hoops before that as far as presenting the witness what the statement is. And depending on whether they admit or deny that it's them on that video or interview or whatever the case may be that you're referring to. But I'm inclined to strike him as a witness at this time, allow him to be present if he so chooses in the trial. But then again, if you wanted him as a witness, you would need to subpoena him. But at this point,
Those pesky rules.
I'm going to strike him from the witness list and permit him to be in the courtroom. If there's a situation where you think something has happened during the trial where you think he should be called as a witness, I guess we'll cross that bridge when and if it comes. Okay.
We could just call him up from the back.
Well, we'll address it when and if it comes. Yeah.
And Your Honor, I would ask that if that were to occur, that I would be notified and given a chance to appeal.
Of course you will. No problem with that. Kitty said, does the prosecutor have to be nice to a pro se lawyer in front of the jury? Usually you would try to be. They don't have to be. I mean, they're supposed to be cordial in a courtroom and respectful of the judge, the other lawyer, whether it's pro se, the other parties, witnesses, etc. I would say you try to make sure the jury doesn't think you are railroading a pro se defendant. That's what you really want to make sure. It's just a fair process. Diva Dawn said on Court TV, they said the police determined the shooting was self-defense and didn't charge Alex. If that is true, why are charges being brought now? They have more information that it was a conspiracy, a plan, somebody was lying. I don't know. We'll see. We'll see exactly how the state proceeds. But I do think this was potentially a winnable case, depending on what they have. I don't know all the text messages and information. That's why we watch the trial. That's why we follow it. But law enforcement has already come to the conclusion once that it wasn't a crime and it was self-defense. Can Lori Vallow convince a jury that that's true? And that's not her burden, of course. The state has to overcome that reasonable doubt. But that's what it's going to feel like in this trial. Push for self-defense and see if this jury will agree with the original call in this case. Chris K. Peter, how would she be able to impeach a witness with just her notes and no video transcript as proof? She wouldn't. Everybody kind of bypassed that part. Nobody really discussed it because everybody else in the courtroom realizes that's not, in fact, a transcript of the video, but they're kind of under the assumption that she would play the recording as impeachment and everybody would be able to hear it at that point. No, her notes would not be qualified to impeach somebody, or everybody wouldn't sit there and agree like, yes, your notes are a fair and accurate representation of what was said in this interview. All right, they go through a bunch of the witnesses the state couldn't get a hold of. Vallow says they've already interviewed everybody. The judge is like, that's not how it works, just because law enforcement interviewed them 5 years ago. And during this back and forth is when Lori Vallow really starts to go off.
Now, and they should be being issued currently. The state talks about in their response, like the state is claiming trial by ambush from the defense. Trial by ambush. How is the defense trial by ambush when they have interviewed every single one of these witnesses before in the last 5 years since this case started? They've interviewed every single person that has been on there. They have written, transcripted interviews and video interviews of all of these people. And so how they are relevant, these witnesses will testify if and when they are needed to add additional facts or fill in the blanks that the state will no doubt leave out in their case in chief, and they'll be called accordingly. I need them to lay perhaps foundations for evidence presented by the state. The same with Lonnie Dorkin. I need his testimony will be required if and when it's necessary to rebut digital information that the state will bring forward during trial. I feel like.
And the judge already struck that witness basically because it's untimely. And it did almost feel like, and he's going to do it again here, where he almost like baits her with, we gave you the chance to continue the case. You don't want to waive your right to a speedy trial, which he's right. Just kind of the tone and demeanor. And I understand some judges get annoyed at pro se defendants. I can't say I'd be any different if I was on the bench, but I would try to say, yes, Ms. Vallow, I understand. Would you like to continue the case? And then when she says no, just move on. Don't tell her it's like, well, that's your problem. That's why. It's like, there wasn't enough time for you to get this expert in place. You don't want a continuance. We've got to move on without him because we have rules and this didn't fit within the rules. And that's what the judge says. But I think that's what kind of adds to her frustration is multiple times he's like, well, you want this speedy trial.
Like the state is trying to say, okay, if you want your speedy trial, guess what? We're not going to let you defend yourself. Guess what? You can't have any experts. And guess what else? You can't have any witnesses. You can't have anybody speak in your behalf. So good luck. Have a nice day.
All right. Well, that's why attorneys.
And it's not even that they're saying you can't have all these people. You're just not following the rules. That's the problem. You're not following the rules. You wanted a speedy trial. You wanted to represent yourself. That's why over and over again, we ask defendants on the record, we put them through colloquies. Are you sure you want to do this? And when they say yes over and over again, by golly, almost every time we have a moment like this where they're like, this is so unfair. I don't know the rules. You guys are doing all this stuff. You guys are telling me all this stuff. None of this makes sense. It's so unfair. It's like, we agree with you. It is unfair for you to represent yourself. So why don't you not do that? Why don't you not do that? Don't represent yourself. Then it'll be more fair. Still not ever fair for a defendant necessarily, but more fair.
Everybody speak in your behalf. So good luck. Have a nice day.
All right. Well, that's why attorneys sometimes take a long time to prepare for a trial because they need to give notice of what all the testimony their witnesses are going to give. They need their experts to prepare reports. That's why your prior attorneys and your current attorneys were asking for more time to prepare the case. So you can't really have it both ways, that you want your speedy trial rights, but you don't want to give notice to the other side of what your evidence is.
I don't not want to give notice.
So I wouldn't have necessarily put it like that. He did. It's fine. There's nothing wrong with that. It's true. I would have just said, Ms. Vallow, you want this trial date. So that's how we set all of the dates when things are due, based on that trial date. And because of that, the date has passed. We have to move on. That's basically how I would put it. But how he put it is not wrong. It's just, to me, When you start to get angry, you start to get worked up, your life's on the line. People can say she's already in prison for life. She's appealing that, whatever. She's still fighting this, and she deserves a fair trial here in Arizona. Tingles, yes. Hit that like button, everybody. If you have not already, please take a second and hit it.
To the other side, with the limitations at the incarcerated state where I am, and the limitations with OPDS of getting Lonnie Dworkin late in the game that they did, I've done everything in my power as a defendant to prepare the state and to give over everything that I could do within my power, with the limitations that I am an incarcerated person at this maximum security prison jail.
So when you say,
and I shouldn't be able to represent myself because of that fact, that negates my constitutional right.
I didn't say that. All right. I said,
and you can make it sound bad if you want to, but it's like, there's a lot of reasons why, right? You're incarcerated because you're convicted of taking the lives of multiple people. You are representing yourself because you're choosing to. So yes, you are allowed to represent yourself, but there are negatives to that, which have been fully explained to you. Your speedy trial. You absolutely have a right to that. Every defendant does. Most defendants waive it because the way our system works, the way the wheels of justice turn is so slow. You can complain about that and say it's annoying and frustrating and not fair. I would agree with you. I make those same arguments. But when you put all of the rights that you are entitled to and you want to lock all of those in, sometimes you're waiving other opportunities to do things like present certain defenses, bring on certain experts, gather certain evidence because of the timing, because you don't know how to, and you want to use your right to represent yourself, even though you've already been convicted of something. So that's why you're going to be in prison.
that sometimes there are reasons to not go forward to trial as fast as you want. All right. So when you say things like they're going to fill in the blanks, that makes it really hard to assess what their relevant information is.
They have relevant information to a lot of factors that I got in the 404B information. For example, the life insurance. My father is a life insurance salesman. He worked with Charles on getting both life insurance policies, my $2 million policy and Charles' $1 million policy. He also tried to sell my insurance policy after Charles passed away. He also told me to go to call the insurance policy and said how to do that, how to call them when you're the beneficiary. I didn't know.
That sounds relevant to me. That sounds relevant. If her dad has that information and the effect on her and why she did certain things, it was not because something nefarious was going on. It's because her dad said, hey, you need to call on this. If that's true, of course, that sounds relevant.
Know how to do any of those things. He has relevant information to that. My sister has relevant information to my brother, Alex Cox, and the whole situation of what happened on July 11th. These people have relevant information to the state's case, what they're accusing me of. There's very relevant information from a lot of these witnesses.
So what I'm struggling with is you just saying that it's relevant doesn't actually make it relevant. It may be.
That made me laugh. It's like one of those things where it's like, that's so true that it's kind of funny. It's like she's making arguments, and I would agree that there is relevance to some of what she's saying, but her argument is it's relevant because I say it's relevant, and it's like, that's not the best argument. So that's why judges sometimes in pro se cases, they do have to kind of apply the law themselves and try to figure out if something she's saying is relevant, even if she's not making the right argument. Some of them do, some of them don't. But he's like, just because you say it's relevant doesn't make it relevant. It's like, ain't that the truth?
Relevant. I'm trying to find out the relevancy. What you said about your father being an insurance salesman and selling policies, that sounds relevant. It could be relevant to me. Who's your father? I don't know who your father is.
Barry Cox.
All right. Barry Cox. It sounds like even from what you're saying, though, you're not,
Pause.
depending on what the state produces at trial, you're not sure that these witnesses would have relevant information. It just depends, is what it sounds like.
Whatever they put up in their case in chief, am I not allowed to try to defend myself against that?
You're absolutely allowed. I'm just trying to figure out, I'm sort of a gatekeeper, and I need to make sure witnesses have relevant information.
And then she does stuff like that, right? Where it's like stuff we talk about, we're really passionate about. It's like you have a right to defend yourself, a right to a fair trial, a right to a speedy trial, a right to counsel of your choice. Like you have these rights, we need to protect them, we need to fight for them. But then she's like, so you're saying I'm not going to have a fair trial? He's like, no, that's not what I'm saying. Like if you have a legitimate problem, let's talk about what your legitimate problem is. But just to kind of whine about stuff is, again, not something a lawyer would ever do. Well, some lawyers actually would do, but it's very ineffective. I'll just put it that way. Very ineffective.
And just like you have the right to interview all of the state's witnesses, excluding victims' rights, people that can deny having an interview, they have the right to interview all your witnesses prior to trial so they can have an idea of what those witnesses might say on the witness stand.
I understand that, Your Honor.
So
They also have already interviewed all of them.
I'm not talking about police interviews or interviews that may have been done years ago. The prosecutor has the right to interview any witness prior to them taking the stand, just as you do. So I'm not sure the best way to handle this other than maybe we should take it up as we progress through the case, but
Your
some
Honor,
of these people may
The state will hate to do that. You hate to do stuff like that, especially with a pro se defendant. It's like, oh, we got to kick the can. We got to hear more of these arguments that don't make sense. It's going to take so much time, energy, and effort. I wish we could just handle it all now. Triple B said, Peter, how do you think Lori's tone will ultimately affect the jury? It depends, right? It will absolutely affect the jury profoundly. Will it be positive or negative? We have to wait and see. Because I personally, if I've watched her make some arguments, some of the tone has been fine. Some of it has not. And if her plan is, which again, the pro se case I tried, his plan was to basically make it seem like the world is against him. It's so unfair. All this these people call justice. It's not justice. That's basically how he acted. It was wild. He was, again, kind of going after a police department as part of his case. And from my perspective here, if she makes arguments, if she does her best, I think the tone could have a positive effect. If she whines and basically says this is so unfair and makes me like, they're not letting me do anything that I want. I have all these witnesses to call, all these experts, and they won't let me. And you try to get that out underhandedly, even though you're not supposed to in front of the jury, I don't think it'll go well. Patty, in my opinion, I'm so surprised she is considered mentally stable to represent herself. It's going to be a circus. My empathy for Charles is deep. He tried hard. Patty, yeah, the bar for competence is really not the highest bar in the world. And I'll tell you, I haven't seen anything in the court appearances and her arguing that would make me question her competence. That's just my opinion. I'm not an expert on that, but I have been involved in a lot of cases where people have been competent, not competent, questionable. And even when I worked for the state attorney's office, I did some of the stuff that dealt with Baker acting and people being found to be incompetent and different processes like that. And that's just my perspective. That's what I see.
may or may not be even served.
Yeah, my concern is obviously I have attempted to reach these people. I've made my good faith effort. I've been told both by myself and attempting to contact them, as well as the defense investigator, that they've been unable to reach them. So it seems to not be following the rules of procedure or evidence to then bring up later on if they perhaps find these people at some point, then the state can try to at that point preclude them. When the state talks about a trial by ambush, it is in fact that. When the defense investigator themselves cannot find these people and are still looking for them in trial when they've had at least, we'll say, 4 months to try to find them.
And that was a new revelation to me that I hadn't heard before, that not only can the state not find these people to interview them, but they interviewed the defense investigator who works for Lori Vallow, and he hasn't talked to any of her witnesses, which is why this is kind of a nothing burger. It's kind of much ado about nothing. She says she has all these witnesses. She says they have relevant things to testify and they will fill in the gaps and all sorts of other vague comments that she's making. But in reality, she probably hasn't talked to many of them. They're probably not actually good witnesses for her, and it's probably not going to go the way that she expects it to at trial with these witnesses. NFL Rising said, Peter, doesn't discovery give her info she needs to deduce what will be presented in the case in chief? Non-pro se defendants depend on it. No. Yes, but she would have to know how to look through it, what to look for. And if she wanted any additional information, she would have to know how to propound discovery to get the information back that she wants. Can the judge really preclude all her witnesses because the state cannot prepare timely? So he can preclude them if the state doesn't have the opportunity to interview them, is what they call them, depose them in other jurisdictions, get their statements. If they don't know if they exist and they can't even have an opportunity to talk to them in Arizona, then yes, it sounds like it's not timely disclosure in enough time for the state to be able to do their discovery on those witnesses, because the state's got to be able to make arguments. These aren't relevant witnesses. They shouldn't be able to testify. Or if they do, and I want to call a rebuttal witness, I need to know who to call. And if they can't do any of that, then they're not going to be allowed to be called as witnesses. And again, the timing is an issue, and because of the speedy trial, and because she's representing herself. Those are the two major issues. Obsidian. She already has life without parole, isn't speedy trial right potentially for not imprisoning someone unjustly. Why does she still have the right speedy trial? And why do you think she's using it? Everybody has the right speedy trial because we don't want you to just have to sit waiting to have this case held over your head for years and years and years, which happens to so many people. But why is she using it? I don't know. I think she thinks it's a golden ticket of some sort because it was a huge win for her in Idaho. She was able to remove the death penalty by her lawyers making the argument that they violated her speedy trial right. So that was a big win. But I don't see it getting her any benefit here except to have some final ending of her case sooner rather than later. And she doesn't want it to last forever, I guess. That's really the only benefit I see from the speedy trial. I don't see this helping her. Peter, would you have struck the expert? I wouldn't. If I was the judge, I would have probably given her maybe some time period before she called the expert to give the state everything they need and make sure the state could interview that expert prior to that expert testifying. And then the state could call a rebuttal expert, even if it's a late disclosure, of course, at that point, because of Vallow's late disclosure. I probably would have tried to find some procedure that would allow the possibility of this expert, knowing it probably still wasn't going to happen. I would have tried to work with her just because it's pro se defendant. Maybe that's not fair or right, but I'm always going to try to do that, try to protect the defendant's rights, try to give them a fair trial, try to do everything I can to help them put everything they can in front of the jury so we don't have appellate issues. And whatever the jury's verdict comes back, we can be confident that is the true, proper, and correct and just verdict. But if I felt like that was impossible, then yes, I would have struck the witness.
I think that at this point, precluding them is proper.
Well, I would preclude anyone that doesn't submit to an interview with the state. I kind of want to punt this a little bit just because if there's people that don't end up getting served, don't end up showing up at court, they can't find, then we don't need to waste our time talking about whether or not those people have relevant information, because
Judge is like, I have a feeling we're not going to talk about these people again.
they're not going to be here and they're not going to testify. So I'm putting the defendant on notice that if these witnesses aren't served, if they don't submit to interviews, they're going to be precluded. Even if they submit to interviews, I may have to make a determination whether their testimony is relevant or not. So again, we're going to, I think, have to cross that bridge when it comes. The state did say that they concede that some of the witnesses, Adam Cox, Janice Cox, Summer Shiflett, may have some minimally relevant information. The rest of these, I think we're gonna have to take up maybe on a piecemeal basis, but I don't want it. It's not gonna be a situation where you're ready to call them in as a witness the morning of, and then the state they haven't been presented to the state for an interview prior to that. So keep that in mind when coordinating with your investigator. If he gets them served and they're actually going to be called at trial, they need to submit to an interview in advance of their testimony.
Your Honor, I understand that. And I am limited in what I can do. If I could call these people myself, they would answer my call probably, and I could have this discussion with them. But I'm going through the limitations that I have at the jail through my paralegal who's working overtime and my investigator who's working overtime to try to do everything to help me prepare for trial, as they have other clients as well that they have to do things in a timely manner for. So we are doing the best that we can.
Okay. All right. We next have defendant's motion to dismiss for violation of confidential communication in the Sixth Amendment dated March 18 of 2025 in the state's.
This one's kind of interesting too, right? She says the state got a hold of attorney-client privilege information, is now trying to use it. They're disseminating it improperly. It's interesting how this stuff happens, right? Because everybody can, crack a joke if they want to about Lori Vallow, but some of this stuff is like, why are you doing this as the state attorney? This is one of them. It's like, why didn't you just, in an abundance of caution, act differently when you got your hands on this information? I don't like it. Is it a big deal? In this case, is it going to affect this trial, I should say? No. But I still hate to see stuff like this.
Response. Let me ask. Did you say you did or didn't?
I did.
Okay.
Yes.
If you have an attorney in Idaho that is working on an appeal, it appears that the information that was turned over by the jail was some pretty innocuous messages about trying to set up the legal line to talk to you on a confidential line. And really, that's about it. So how does this?
The judge at this point believes that the comments that they have are limited to like 2 or 3 messages, but there's more on there. And he basically says, oh, this is no big deal because once we all figured out what happened, we stopped and ceased getting these communications. And that actually is not the case.
Rise to some sort of nefarious interception of things because it was put on a public chat system that the jail uses. You know, it's not confidential, and you're told it's not confidential. And then even if I look at the substance of the messages, there's really nothing in the messages that would arise to some sort of confidential communication, just trying to set up a meeting and get the unrecorded legal line set up.
Who's saying that they're not confidential?
Well, the
Who's
jail,
telling me that they're not confidential?
your own attorney, it looks like. Here's a message. I see that they came and got you. I'm working on getting a confidential attorney line set up. The implication being that this message is not confidential. The next one, again, just checking in. Hope things are getting a little better for you. I'm still working on getting a legal line set up. The implication is that these are not confidential.
Okay, so then he received a letter from MCSO that said, your phone number is now confidential and arranged for privileged, confidential client privilege communications. So
Phone
from
calls.
my no, it says this phone number is connected to that. So from my perspective, when I call someone on the tablet or when I text someone on the tablet, it goes to their phone number. So all the communications after the date of the exhibit that we put in our motion, when he got that letter from MCSO that now all of your things will be confidential.
Okay.
Now they will be confidential. So my understanding, and I'm the only one that can waive that privilege, right?
And I think after that, when his line was approved, there were no other disclosures of messages between you and him, correct?
No, there are.
You received other disclosures of intercepting messages between you and him?
So those go up to the 24th of January.
No, the only thing I saw was up to, I think, late December of 23.
Okay, so there are confidential things that are in our communications because I was not aware that after he received that there were not. So the prosecutor who obtained these, her protocol would not be to stop and ask the court for some guidance on this, maybe do an in-camera review if she's subjecting herself to client privileged communications, instead of reading them and finding out and assessing for herself if there are anything in there that's confidential information between me and my appeals attorney. I have no other way to communicate with him when I'm in this incarcerated situation because I was brought here to Arizona to deal with these charges. So
just my quick thoughts on this, right? The attorney probably didn't do the best thing. She can talk to attorneys on a confidential line once it's set up. Maybe he didn't do it right. Regardless, here's what I would do if I was a prosecutor. I'm not going to read these. There's a taint team. You can give them to the judge for in-camera review, saying, Judge, we don't think these are confidential. We want somebody to tell us if they're not before we review them. We're turning it over. We're letting everybody know. That's my bent in an abundance of caution. I don't want to get anywhere near the line. But no, these prosecutors just read them, turned them over to the defense. Now we're figuring out if they're confidential or not. Now that the prosecutors know they don't want to use them. I just don't like that process, right? That stuff should be sacred. We should make sure. And then once somebody tells me as a prosecutor, I can look at this. This is not confidential. Then I will look at it, see if it's relevant, see if I want to use it. Okay. And we're going to apply the same rules to Lori Vallow that we would to Karen Reed, to anybody else, Brian Koberger, any other case that we are following, because I think if it happened in some of the other cases, people would look at it differently, but because it's happening in Lori Vallow, NBD, I disagree. I think it should be looked at the same, regardless of who the defendant is and what the case is. Northwest said the only thing the state did was turn it over to the defense. No, they also read it, right? They also reviewed it themselves, which that's the problem I have. I agree later they're going to say they didn't turn it over to Idaho. They didn't disseminate it or things like that Lori Vallow accused them of doing. But it's just like, let's be careful with that stuff. Aries, after watching her behavior this way, it's going to be wild when she acts like an angel in front of the jury. Would that be something? She is so manipulative, and I can see her possibly swaying jury, emotionally playing the victim. I don't think so. I don't think she's going to be able to keep it together in front of the jury, but there are some lawyers that act like wild when there's no jury around and then sweet as pie. And I'll admit sometimes I'm a lot more aggressive in hearings than I am in front of a jury. I wouldn't call it manipulation. I would call it making sure that you're being respectful and acting appropriate for the environment that you're in, right? Like how you would act with all your boys is different than how you'd act if your kids are around or if your parents are around, right? Or all of your girls, if it's, the ladies out there, it's just different. You have different vibes depending on the environment you're in. You're not a different person, but the way that you argue and fight for yourself and you're fighting for justice, the passion can come out a lot more in a hearing, and you're trying to be a little more reserved in front of the jury so they don't think you're wild, right? Or they don't think you're mean or angry or bullying a witness or bullying a judge. John, watched your new Karen Reed podcast with your pops last night over dinner. Maybe I'm biased, but possibly the best one yet. Isn't that interesting? I was in a hotel room in New York for reasons I will discuss later with the channel as a whole. It's really fun. But it was like 11 o'clock at night, which is where he thrives. He's a night owl. Nothing seems to affect him. He is so neutral. Chat, check it out. Thank you, John. Yes, I would agree. Patty, Peter, is it possible that people she's naming don't want to be found? Yes. Is that allowed? I've listened to some of them and I'm not sure they do. Is it allowed? You're not supposed to dodge subpoenas. You can't violate a subpoena if somebody tells you to show up for court. But if they can't find you and they can't serve you, then you don't have to show up.
It is a problem. It's a problem that she took them. It's a problem that she got them from MCSO. It's a problem that she read through them. It's a huge problem that she put some of them into her motion, and now his IP address is exposed to the public, which is a federal offense. There's a lot of things wrong with what has happened here.
Well, you reminded me that when his number was approved, he then sent messages from different IP addresses instead of that phone number that was privileged. So he's the one that disclosed or violated the confidential nature. I don't see that any of these, I'm going to call them inadvertently intercepted messages between you and your appeal attorney. I don't see that they're being used in any way by the state.
Just the state reading them as a violation of the client-attorney
Well,
privilege.
not if they're not done through a privileged setup the way that they were supposed to, which he even acknowledged.
My understanding from my perspective was that that phone number was now privileged. The way it comes to me on the tablet is I text that phone number or I call that phone number.
Correct.
So
If you're communicating through the phone number, but if he has it set up where the messages aren't being sent and received actually through the phone number, but through different IP addresses, the system doesn't know that they're privileged because they're not being sent and received through that privileged number.
but I didn't know that. There's no way for me to know that from where I am in my cell. There's no understanding for that. I assumed he was just getting them on his same phone that we were having client-attorney privileged communications.
There's no doubt there were some screw ups, and potentially this stuff could have been turned over to the state eventually anyways. And it sounds like it's going to be nothing relevant to this case, and the state didn't forward it along to Idaho, they say. So, it's not going to be a big issue. This stuff I'm really touchy about.
And is the state giving these to Idaho? Do these get dispersed out? I would like to know that. Where are these going? They're getting them from MCSO. Is there a subpoena to get these from MCSO? Is there a warrant to get these from MCSO? I didn't see anything that warrants them getting them from MCSO in the first place.
All right, let me hear from the state.
And I think that the state's motion really covers the law under this. The defendant and her attorney were provided with information, whether or not she understood it or not, her attorney understood that it was phone calls that were covered. So it's not just the defendant who is not complying with following the correct procedure to utilize the set up attorney-client privilege means to communicate. In this case, the state, obviously, I disclose those before I even look at them. I understand that they are statements by a defendant, and I believe that they are to be disclosed under Rule 15. And so before I even look at them, I send them to the defendant because I don't have the option of not providing them to her since they have been obtained. I think if you apply the case law in this, the defendant cannot meet her burden to show that there's any legal advice in these messages. There's no privilege in them. The messages are asking to set up.
It does not need to be legal advice to be privileged. Conversations with your lawyer, even if you're calling him up and you're saying like, hey, I want to make sure we get this set up. That should all be confidential and privileged. It's not like you get some of the conversation and not others. It's not like you say, okay, the first sentence was legal advice, the second sentence was not. So you can read the second sentence. That's not how it works.
Times to call and to speak.
Are the three, I think it's 3 messages that you included in your response, are those all the messages?
No, Your Honor, there are other messages, and we do say that tablet messages between Ms. Daybell and Mr. Jerem do not end on December 28th. They continue.
And there is privileged information on them going forward. And the state is basically testifying for my attorney now. She just testified for my attorney that he understood that that these were not privileged communications. Where does she understand that where is she testifying for my attorney?
Well, I think because the context of the messages say, I'm trying to schedule a time and I'm trying to set up a confidential line, meaning
That was
this is not
before.
confidential.
That's right. He said it wasn't confidential before MCSO gave him a letter saying your phone number is now confidential. Your phone number now has.
Okay, I'm not going to keep rehashing this with you. The fact that he's using different IP addresses and not messaging through the actual phone number that's protected, I think is part of the problem. So if he's not using the program correctly, that's an issue you need to take up with your attorney.
How is he using it incorrectly?
I just told you. He's not messaging through the phone number. He's using different.
And if you remember, we talked about this with Karen Reed, inadvertent waivers versus intentional waivers. There's a big difference. And everybody's making this out to be just no big deal. It's not really the point of this video, so we don't have to get into it too much, but this happens in more than just the Karen Reed case, I guess. This highlights that.
different IP
How
address.
can you message other than the phone number? I don't understand that.
I don't understand that either, but if it was from the phone number and it's for his cell phone, for example, it would be the same IP address for each communication. There's like 4 or 5 IP addresses.
Where are the IP addresses coming from? They're given to you by the state?
They're right there listed on the messages.
I'm just saying, where are they obtaining those from?
From your attorney's messages to you?
From MCSO?
Yeah.
Did they get IP addresses for every single person of every single message communication on the text from MCSO?
Well, it's listed on the messages, so I assume so. It says Craig Durham, and then under it is the IP address from the device that's being used.
Okay, and then Ms. K is reading all of these messages and they're not privileged. Is that what you're coming to?
They're not privileged if you're not using the program or your attorney's not using the program correctly. Okay, they're still not going to be allowed to use any of these messages. What I'm saying is they're inadvertent disclosure by MCSO because someone's not using the program correctly doesn't mean that they had bad faith in how they got them. They made
How is he using it incorrectly?
I don't know how else to explain it to you. I've told you 5 different times now. So he's not messaging with the phone number. He's messaging from different IP addresses.
Okay, can I ask if these messages are being disseminated anywhere to Idaho, to the prosecutors in Idaho? Because that's definitely affecting my appeal if that's the case.
I don't know.
Have not been sent to anyone other than the defendant, Your Honor.
All right.
That's good.
So
All right. So that is the end of that conversation. Then they start talking about a motion to dismiss for prosecutorial misconduct. Lori Vallow argues that the prosecutor blocked their public records requests and is blocking her ability to even defend herself in this trial as a whole.
state distributed attorney-client privileged communication. We've discussed that. The next one is legal advice to the defense witness, Nate Eaton. We've somewhat discussed that, but I think their motion, the state says that they simply.
It's taking her word for that that's what happened. It's taking her word for that that's what happened. She's not under oath saying that that's what happened. Nate Eaton's not here to testify that that's what happened. They're the only 2 parties that are there to say that that is what happened. So that is my problem with it. I would like for one of them to get on the stand and say exactly what happened in that conversation and that she wasn't giving him legal advice. How do we know?
So she's arguing that the prosecutor was giving Nate Eaton legal advice when she said, well, if you haven't been subpoenaed properly, you don't have to take the stand. You don't have to testify, things like that. Which, I mean, that's just such a simple thing. A lawyer's like, well, did she subpoena you? Well, then you don't have to testify if somebody's asking. Potentially that could be seen as legal advice. Potentially that could be seen as that's what prosecutors probably do to a lot of witnesses that the defense calls that they don't want to come and be a witness. They're like, that might be the first question. Well, did they subpoena you? Because that's the only way they can make you come and testify. But again, she's pointing out things that I think in other cases we might be like, ooh, but in this case, we're like, oh, it's Lori Vallow, so whatever. But she's also asking for things that are totally inappropriate, never going to happen. Like the prosecutor is going to get on the stand to talk about what she and Nate Eaton talked about. The prosecutor could just say from where she's sitting, no, judge, we didn't have any conversations. I just said, did she subpoena? You said, no. I said, okay, that's it. Like, you don't have to actually have a big hearing, or they don't sit there at trial and testify about this stuff, which is what she makes it seem like is going to happen.
No, that she wasn't. It's a very curious situation that he called her, and then he writes in his motion this statement.
It's actually not curious at all. If whether you're Nate Eaton or not, who's somebody that understands the process and is involved in the process, if you're just an average Joe and a defendant calls you to, or subpoenas you or tries to, or wants to call you as a witness, it's very normal, if you're not friendly to that defendant, to call the prosecutor and be like, do I need to show up to this? What's happening? It's not abnormal for witnesses to do that.
That obviously comes from Ms. K. She seems to be a clear attempt by Ms. Daybell to use the rules of criminal procedure as a pretext simply to keep me out of the courtroom and interfere with my ability to report. We also don't know if he told her, don't come to the March 18th hearing, because that's when they're going to serve you with your subpoena. So all these things come from there, and we don't know who's saying it. And you're just taking her word for it, like you took her word for, oh, there's only 6 emails and there's no other emails. You're just taking her word for it as an officer of the court. And I think that she should have to be sworn in.
Well,
Whoa. And she uses an argument that she kind of won, although I'm not sure the prosecutor said it was only those messages. I think the judge surmised that maybe by a filing that he was looking at. The prosecutor said there was more than past December of 2023. Those were the lawyer messages we were just talking about. But Lori Vallow's like keeping track of stuff in her head, right? She's not dumb. She's not dumb. She's like, you're taking her word for everything, Judge. I just proved her wrong with those attorney-client messages that, you thought she was telling you the truth as an officer of the court. Let's swear her in, Judge. It's like, yeah, you take it a couple steps too far. It's like, you're not going to ever swear in the prosecutor for something like this. Let's just have a discussion here like civilized adults. But she's getting very mad.
you want me to just take your word for he must have gotten these things from Miss K. Okay. Just because.
Good point. It's like, this is what it's called to make an argument, Ms. Vallow. It's like each side makes an argument and the judge makes a decision. So Ms. K is going to make an argument. It doesn't mean she now has to be sworn in, right? Gold Dust said, I've heard lawyers with the same kind of attitude. I agree. And I would not like it from them either.
Because his motion says he thinks that you're noticing him as a witness to keep him out of the courtroom. I don't know why you take the jump to that is coming from Ms. K as opposed to his own volition. He also hired an attorney that said the same thing. Even if she had said you need to be served with a subpoena to have to show up in court, that is not an ethical violation.
Well, giving legal advice is an ethical violation. Is that correct?
Stating what the law is not an ethical violation. If she said, I don't think you should show up at court, even if you're subpoenaed or something like that, that could be an ethical violation, but we don't have that.
How do we know we don't have that? That's my question. How do we know what went on in that conversation if it wasn't recorded? Aren't witness
You can
interviews
interview him.
recorded?
You can interview Mr. Eaton.
And this is where Nate Eaton was probably like, oh boy, here we go. He said she can interview me. Then he kind of backtracks. Is like, tell your investigator, interview Nate Eaton. So I wonder if that's going to happen.
Investigator can interview Mr. Eaton. So when and if you get that information from Mr. Eaton that something nefarious happened in that conversation, bring it up then. But you're jumping to conclusions. You have the right to interview any witness. Okay.
not a witness anymore because you just precluded him?
All right. You can interview him. You can have your investigator interview him.
So even though he's not a notice witness now, we can still interview him and try to find this information because we can't get it now? Is that what you're saying?
Sure. Have your investigator call him.
It's like, sure. Is that what you're saying? Sure, Ms. Vallow. Go ahead. Interview Nate Eaton. It's like, he's not going to tell you that this prosecutor did something unethical. And that's the thing is, again, I'm not going to tell you I've never had a witness that swears things are going to go a certain way. And I'm like, I don't think they are. And then when they don't go that way, I'm like, it's just not the logical step of how things are going to go. And that's why you've got to talk to clients sometimes. Let's not waste time doing the stuff that we know is not going to work. Sometimes they push, sometimes they really want it. Sometimes we can come to an agreement. Sometimes we can't, but this is her pushing these points that she thinks is a really great argument, is a lot of leverage, and she gets a win on something like, haha, I told you there were more messages. Haha, great, I get to interview Nate Eaton, but it's not really the wins that she thinks it is.
Ask him about the conversation. At this time, I'm going to, based on just the pleadings, I'm denying the motion to dismiss for prosecutorial misconduct.
I don't know if you heard that, but on the screen, you see this "of course" right here. Right here, it says "of course." That's Lori Vallow whispering it under her breath. I'll back it up one more time. He's like, "I'm going to deny the motion for prosecutorial misconduct." She's like, "Of course." And I mentioned that to mention she better be very careful about a hot mic. If these mics are going to be on the table, if I was her standby counsel or anybody watching this that supports Lori Vallow, I would write a motion with the court to say, "Judge, they need to bleep that out." They're on a 30-minute tape delay, by the way. They need to bleep out anything they pick up from counsel table because no spectator sitting in the audience would be able to hear that. They have these highly sensitive mics. They should not pick up our conversation at counsel table. That's an easy motion to win. And they should do, because if they start streaming stuff like this, it's going to go bad for her where she's like, "Of course," or muttering things under her breath when a judge makes a decision. I'm going to play it one more time so you can hear it.
For prosecutorial misconduct. This time, I'm going to, based on just the pleadings, I'm denying the motion to dismiss for prosecutorial misconduct.
Of course.
All right, 609 motion. The state's alleged.
All right. Maxine said, "Peter, if a real lawyer keeps interrupting the judge, would that lawyer be told to be respectful to the court?" Depends on the judge. They could be reprimanded by the court depending on how they're acting. I don't think she's going overboard here. I know people are saying she's being disrespectful. I don't think that a judge, I wouldn't feel disrespected by her. I would take no offense by what she's saying. I figure she's arguing the best that she can. Her life's on the line. She's representing herself, which is a mistake, but she's still doing it. I don't think she's been she ain't no Daryl Brooks. Okay, I'll put it that way. So I mean, at this point, lawyers and judges usually have pretty thick skin. It wouldn't bother me that much. Now the stuff that she's done and been convicted of would bother me in a very real and large way. So that's what I would, you have to put aside as a judge and just focus on this case. Azam asked, "Peter, so if the trial needs to be a continuance, does that mean her rights are violated?" She would have to agree to a continuance at this point, or it would violate her speedy trial rights. So the state cannot force a continuance. The judge cannot grant a continuance unless Lori Vallow asks for it or agrees to one. And the only way she will be able to do that is to waive her right to a speedy trial. Also, off-topic question. How does a certain case become case law? What is the process? So in simplest and quickest of terms, something happens, either a judge's call or a trial, it gets appealed, an appellate court makes a decision, and they say, "I'm making the decision because this is the law." That is now case law that you can use in other cases. You can't, because you get like a trial and it gets a verdict of $1 million for a broken leg, you can't say now all broken legs are $1 million case. That's not how case law works. But if they say a doctor can testify to the future treatment you need on that broken leg, because now you're going to have osteoarthritis or whatever, and you need all this treatment, and that is allowed as expert testimony, and one side appeals and say that shouldn't have been allowed, the appellate court comes back and says, "No, that is okay. It's within the doctor's area of expertise to opine on that." Now that's case law you can use to argue in other cases that doctors can opine on future medical damages on a case. And now that is the case law because it was appealed. Appellate court gave the decision as to why. Hopefully that was simple enough. Okay, so that's it. And Lori Vallow's case, they're picking a jury there here in April. We're picking a jury in Karen Reed. So it is heating up in the true crime world here in 2025. Then we've got Koberger that's going to follow on the heels of these two cases, and it's fast and furious. Hopefully you guys are ready. Make sure you hit that like button. Anybody that's following this case, send them this video. I want to get everybody here so we can talk about this case. If there's enough interest and questions, I will try to follow it simultaneously with Karen Reed as best as I can, as best as is physically possible. I do have a trial in June, mid-June, that I'm prepping for myself. So that is going to come into play here as well as what videos I can and can't do during these trials. But I appreciate you guys so much. I love doing this with you. It's really fun. I enjoy it. I enjoy learning. I enjoy seeing things all over the country. I think it makes me a better lawyer. Hopefully it makes you better jurors and better people in our society to know how the process works, what we need to fight for truth and justice, and to make sure everybody gets a fair shot. So until next time, and by the way, anybody that ever needs a lawyer in injury cases, wrongful death cases, and what I do, please reach out to me. Would love to work with you. Would love to work for you. And if I can't, I will try to connect you with somebody who can. Yes, we can't forget Donna Adelson, YNW Melly. So many cases going on here. We will continue to try to follow all the ones you guys have questions about. But until next time, better than reading Google. Yes, always better. I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.